Okay, Sean and Benoit here, and we're going to go over the purchase and sale agreement. Page 1A, key terms and conditions. This spells out everything that's going to correspond to the next 10 pages of the contract. So we have our property identification, which is the address, and we also have the tax parcel ID number. We also have the deed book and page. Now, under legal description, you could attach a copy of the deed, or if it's a condominium, you would use the F204, or if you had the full legal description, you would check for and put in your full legal description. Number 2, the purchase price of the property is spelled out at $546,000. Number 3, seller's monetary contribution towards buyer's closing costs is spelled out at $5,000. Closing date and possession. Closing date shall be on March the 3rd, 2026, and the buyer wants to take possession at closing. Number 5, closing law firm. Closing law firm is Optimum Closing Attorney, and their phone number is located here. Number 6, the holder of the earnest money. Happy Buyer Realty to hold the earnest money. Number 7, earnest money of $5,600 within 2 days of buying agreement date. Or you could have put 5,600 or whatever amount of earnest money here as of offer date. Or you could have had something totally different and put it here in line C. But for our demonstration here, we're going to check B, $5,600 within 2 days of binding agreement date. 8, inspection and due diligence. For our example, we're going to put in 7-day due diligence, which means the buyer has 7 days to conduct their inspection and cancel the contract if they still need to cancel the contract due to the inspection report. Number 9, lead-based paint. If the home was built prior to 1978, we would attach the F316 lead-based paint disclosure and check was. But for our example, we're saying that the home was not built prior to 1978. 10, broker relationship in this transaction. Buyer's broker is Happy Buyer Realty, and they are representing the buyer as a client. The seller, for our example, is Happy Seller Realty, and they are representing their client as representing their client. Under C, material relationships, there are no material relationships that need to be disclosed on this contract. 11, time limit of offer. The offer is set forth to expire on 6:59 p.m. on January the 29th, 2026. And the buyer has initialed that they have indeed asked their realtor to write the contract, and this is exactly how they want it written. Now, for full disclosure, you could set a time limit for whatever time you want and whatever date you want. But once the time limit expires, this contract is no longer valid. It expires if the seller does not accept the contract by this particular date. Now, what they could do is they could counter offer, accept the offer, or reject an offer. So those are the options that the seller actually has. And I'll see you back on page 2. Okay, page 2 are the purchase and sale agreement, starting with B1. Purchase and sale, further explanation. A, warranty, seller promises good title. Simply explained, the seller is promising that when you close, they will give you good, clean, marketable title, meaning you'll legally own the home without major title problems. They can still transfer the home subject to normal things like zoning rules, utility easements, HOA covenants, etc. If the home has leases, you take over the lease at closing. B, examination. Your right to review title and survey. Simply put, You're allowed to check the title and get a survey. If you find title problems, you can object before closing. If the seller can't fix the issue, you can terminate and get your earnest money back. If a title insurance company would insure the home, the title is considered marketable. C, title insurance, enhanced policy presumed. Simply explain, your lender will assume you want the enhanced title insurance policy, which provides more protection. B2, purchase price. Simply put, the price must be paid in US dollars, often by wire transfer or other method approved by the closing attorney. Purchase price and sale price mean the same thing. Number 3, closing costs. Seller contribution. Simply put, the seller will give the dollar amount you negotiated to help pay your closing costs, but your lender may limit how much of it you can actually use. B, additional costs seller must pay. Simply explain, the seller must pay for anything required for them to transfer clear title, including payoff fees, closing attorney fees for seller-related documents, and costs if the seller can't attend closing. C, buyer's costs. Simply explain, the buyer pays transfer tax, title search and preparation of deed, any additional buyer-related closing costs. D, prorations. Simply explain, property tax, HOA fees, and utilities that can't be shut off get split between buyer and seller based on the closing date. If taxes were estimated or under appeal, both sides may owe each other more money later once the final bill comes out. 4, closing date and possession. Right to extend closing date. Simply explain, either party may extend closing once for 8 days if their lender or closing attorney is delayed and delay is not their fault. B, keys and openers. Simply explain, the seller must provide all keys, fobs, garage remotes, access cards, and codes at closing or provide instructions if those must be obtained from a third party. C, devices and fixtures. Simply explain, if anything in the home needs a controller, password, or access code, the seller must give you all controllers and login information, or reset devices to factory defaults before you take possession. You are responsible for setting up any service plans after closing. And this concludes page 2 of the purchase and sale agreement. Page 3 of the purchase and sale agreement. The buyer chooses the closing attorney. If the attorney works for a law firm, the firm is considered the closing attorney. If the buyer's lender refuses to work with the chosen attorney, the buyer must pick a new one the lender approves. If the buyer is getting a loan, the closing attorney legally represents the lender, not the buyer. If the buyer is not getting a loan, The closing attorney prepares the document, clears title, conducts closing, disperses money, and records the deed, but only for those tasks. Any additional legal work requires a separate engagement. 6, holder of earnest money. Earnest money goes to the holder listed on the contract, often the closing attorney or the broker. The holder may charge fees for receiving earnest money. The holder must deposit earnest money within 5 banking days after binding date or after receiving the funds. Earnest money can't be returned until check clears. If a check bounces or the buyer fails to pay earnest money on time, the holder must notify both parties. Buyer gets 3 banking days to fix it. If the buyer doesn't fix it, the seller may terminate within 7 days, but only if they act within that window. Earnest money, entitlement and disbursement. When buyer gets earnest money back, buyer gets earnest money back if you don't reach a binding contract, a contingency fails, like inspection or financing, seller defaults, you determine a specific contractual right. You terminate for a specific contractual right. Otherwise, it goes towards the purchase price. B, disbursement of earnest money. How earnest money is released. The holder can release earnest money when the property closes, both parties sign instructions, a court or arbitrator issues an order, no binding agreement was ever reached. The holder can also make a reasonable interpretation of the agreement and notify both sides of how they intend to disperse the funds. Everyone has 10 days to object. C, interpleader, when the holder lets the courts decide. If the holder can't tell who should get the earnest money, they can send it to a court and let a judge decide. The holder may deduct their costs or for filing the case. D, hold harmless. Both parties agree not to sue the holder for doing their job and agree to protect them from claims, even if the holder is partly negligent. And that concludes page 3 of the purchase and sale agreement. Okay, we're going to move right along. We're going to take it from the end of page 3 and we're going to go into page 4. Inspection and due diligence. Buyer's right to inspect property. Property is sold as is, unless stated otherwise. Buyer can inspect anything they want. If they're worried about a former meth lab, check the DEA website. B, responsibility to inspect neighborhood. Buyer must investigate things outside of the property, such as school, crime, noise, landfill, power lines, airport, zoning, sex offender registry. Sellers and listing agents do not have to disclose sex offenders. C, buyer's inspection rights continue through closing. Buyer can continue inspections up to closing as long as they give notice and schedule responsibly. Seller must keep utilities on and provide access to all areas. D, buyer's responsibility for damage during inspection. Buyer must pay for any damage caused during inspections, except damage that results from discovering actual defects. E, due diligence period. During due diligence, the buyer can walk away for any reason, request repairs or changes, conduct inspections. If buyer does not terminate before the deadline, they accept the property as is unless the seller agrees to repairs in writing. F, seller's duty to disclose. Seller must disclose known hidden defects that a normal inspection wouldn't reveal. G, warranties, transfer of warranties. Any transferable warranty, such as a termite treatment, HVAC, appliances, home warranties, will be transferred to buyer, possibly at buyer's expense. H, repairs. All agreed repairs must be done before closing and in a professional manner. 9, lead, paste, paint, and hazard materials. Lead-based paint and paint hazard evaluation. If part of a home was built prior to 1978, the lead-based paint exhibit must be attached. The buyer gets 10 days or whatever time both parties agree on to test for lead-based paint. If lead or lead hazards are found, the buyer can terminate without penalty unless they previously waived that right. If the buyer does not terminate within the 10-day period, the right goes away. 10, brokerage relationship and compensation. Agency disclosure. This section explains who represents who and what duties the brokers owe. Key points. Brokers only owe the duties stated in their written agreement and Georgia law. If a party is not a client, the broker only performs basic tasks called ministerial acts. If the same brokerage firm works with both parties, the broker represents only the one who is a client, not a customer. 2, consent to dual agency. If both sides consent to dual agency, then the broker represents both buyer and seller at the same time. The broker must stay neutral and disclose any material facts unless the client makes them confidential. Broker cannot share anything that will hurt one side's negotiating power. Both parties must agree to dual agency. Designated agency disclosure. A broker can assign one agent to represent the buyer and a different agent from the same office to represent the seller. Each agent owes loyalty to their own client. And this concludes page 4 of the purchase and sale agreement. Page 5 of the purchase and sale agreement. Compensation of brokers. Buyers and sellers must pay the compensation agreed to. The closing attorney will show this on the settlement statement and pay the brokers at closing. If only partial payment is made, the rest is still owed unless the broker agrees otherwise. C, disclaimer. Important limitations. Brokers do not check for defects, verify repairs, inspect for termites, mold, radon, asbestos, etc. Check zoning, flood zones, utility bills, or soil conditions. Review legal, tax, financial, or structural issues. Ensure that seller has removed administrative access to smart devices. Buyers and sellers must get professional inspections, surveys, and legal advice. 11, time limit of offer. The offer expires on the date and time written unless two things happen before it expires. The offer is accepted. The acceptance is delivered back to whoever made the offer. C, let's talk about notice. Notice, generally, all notices must be in writing, legible, and signed. Notices can be delivered in person by couriers such as FedEx, UPS, or United States Postal Service. Email or fax. Anyone can physically deliver the notice even if they aren't the one who signed it. B, delivery of notice. A notice is considered officially delivered when the other party actually receives it, the delivery service shows it was delivered, it is emailed or faxed, even if they never opened it. C, when broker can accept notice. If the broker is representing a party as a client, not dual agency, they can receive notices on behalf of that party. Notice must be sent to the contact info listed on the contract. If the firm practices designated agency, only the assigned agent can receive notice. Default, number 2. A seller's remedy. If the buyer defaults, breaks the contract, and the deal doesn't close, seller's only remedy is to keep the buyer's earnest money as liquidated damages. Sellers cannot sue the buyer to force them to buy the home. If the buyer never paid earnest money or the earnest money check bounced, the seller can sue just to collect the unpaid amount. Buyer remedies. If the seller defaults, buyer can sue for specific performance, which is force the seller to sell, or buyer can terminate and get all money back and seek additional legal remedies. And that includes page 5 of the purchase and sale agreement. Page 6 of the purchase and sale agreement. C, rights of brokers. If a party defaults, brokers are considered third-party beneficiaries to a contract. The defaulting party owes the brokers the compensation they would have earned if the sale had closed. If one broker represents both sides, that broker can collect the entire compensation amount. D, attorney's fees. If the buyer, seller, or broker end up in litigation or arbitration, The losing party pays the winning party's attorney's fees and expenses. Number 3, risk of damage to property. The seller promises the home will be in substantially the same condition at closing as it was when the offer was made. If the home is destroyed or severely damaged before closing, the seller must notify the buyer. Either party may cancel the contract within 14 days of the notice. If neither side cancels, the seller must repair the home back to its original condition. Closing can be delayed until repairs are made or completed, up to 1 year from the original closing date. 4, other provisions. Condemnation. If the government starts or threatens a condemnation, taking the property for public use, the seller must inform the buyer immediately. Buyer has 7 days to cancel and get earnest money back. If the buyer continues with the contract, they get the right to any future condemnation money paid by the government. B, consent to non-public information. Buyer and seller agree that the closing attorney can share the Alta settlement statement with both parties and their agents. C, delays caused by emergencies. If the Georgia governor declares a state of emergency in the county where the property is located, all contract deadlines pause for the same number of days the emergency lasts, up to 8 days. If the contract becomes binding during a state of emergency, no extensions apply. D, digital signatures. Digital or fax signatures count as originals. However, if a lender or the other party requests original ink signatures, both sides must re-sign. Duty to cooperate. E. Both sides must act in good faith and do everything reasonably needed to finalize the sale. Buyer and seller must sign documents required by the attorney, lender, and the title company. F, entire agreement, modification, assignment. This contract replaces all prior verbal or written agreements. No one should rely on anything not written in the contract. Changes must be in writing and signed. Buyer cannot assign the contract to someone else unless the seller gives permission. If the buyer assigns the contract, the buyer still owes any broker compensation. G, extensions of deadlines. If a deadline lands on a weekend or holiday, it does not automatically extend, except for the closing date, which can fall on any day. H, FERPTA affidavit. Sellers must sign a document confirming they are not a foreign seller per IRS rules. If the seller is a foreign person, extra tax withholding is required at closing. And this concludes page 6 of the purchase and sale agreement. Okay, we are on page 7 of the purchase and sale agreement. GAR forms. GAR, Georgia Association of Realtors, provides standard forms used in most transactions. No one is required to use GAR forms, and they are written to apply broadly, not tailored to any specific person. Parties must read and understand the forms and consult an attorney if needed. Courts may interpret or even reject certain sections of the GAR forms. Changes to GAR forms must be visible. You cannot alter them secretly or use modified copies unless changes are clearly written as stipulations or addenda. J. Governing laws and interpretation. Georgia law controls this agreement. The agreement may be signed in multiple counterpart copies. Nothing is interpreted against a party just because they wrote it. If a clause is invalid, the rest of the contract still stands. All references to time mean Georgia time. K. No authority to bind. Real estate agents cannot bind buyers or sellers to anything just because they are agents. Agents can only receive notices, not issue them on your behalf, unless signed by you. Agents may fill in the binding agreement date as a ministerial act. I. No recording of agreement. Buyer is not allowed to record this contract or a summary of it in public land records. Doing so makes the buyer liable for damages. The buyer may record a list pendants only if they file a lawsuit claiming an interest in the property. M. Notice of binding agreement date. The contract becomes binding when acceptance is delivered back to the offerer. Either the party or their broker can send the official notice. Whoever receives the notice should sign the binding agreement date and return it. Sending a fully signed contract with the binding agreement date already written in counts as delivery. And objection to binding agreement date. If either party disagrees with the binding agreement date entered, they must object within 1 day of receiving it. Parties then correct the date using the form F733. Not objecting means you accept the date. O. Property to be delivered in clean condition. At possession, the home must be clean and free of trash, debris, and the seller's personal items. Even in an as-is sale, this rule still applies. Firewood does not count as debris. P. Rules for interpreting this agreement. Handwritten changes override printed text. Exhibits override the main contract. Special stipulations override everything else. For FHA, VA loans, the amendatory clause always controls. Broker signatures are not required for the agreement to be enforceable unless compensation amounts change. If a broker writes a stipulation for a party, that party accepts it as if they wrote it themselves and must indemnify the broker. Broker statements about the property rely on information given by the seller, not the broker's independent knowledge. Okay, we're on page 8 of the purchase and sale agreement. We're starting at the top with Q. Statute of limitations against broker. Any claim against broker, lawsuit, or arbitration must be brought within 1 year from when the issue happened. After 1 year, the claim is barred. Okay. R, survival of agreement. Some obligations continue even after closing, including payment of any owed compensation, warranty of title, seller's written representations, buyer's inspection-related indemnities, condemnation rights, attorney fees provisions, property tax responsibilities, smart device access obligations, removal of seller's personal items, any other duties specifically noted to survive. S, terminology. Singular includes plural and vice versa. Pronouns apply to individuals or entities depending on the context. T, time is of the essence. Every deadline in this contract is strict and must be met exactly. 5, definitions. A banking day is Monday through Friday, excluding federal holidays when banks are open. Binding agreement date. This is the official start date of the contract. It is the date the accepted contract is delivered back to the party who made the offer. C, broker. Broker includes the licensed real estate agent brokerage firm, any agents working under that firm, unless the agreement says otherwise. Business day. A business day also means Monday through Friday, excluding federal holidays. This definition is used for deadlines not tied to bank schedules. E, a client is someone who has signed a representation agreement with a broker, buyer broker, or listing agreement. F, closing. Closing happens when a seller signs and delivers the deed, buyer pays the purchase price, all closing documents are signed, closing attorney confirms all funds and paperwork are ready, attorney authorizes disbursement and recording of the deed. Important to note, the deed may not be recorded the same day. A seller may not receive funds the same day due to timing of wires or escrow requirements. G, compensation. Compensation means any fee paid to the broker, whether it be a flat fee, percentage, bonus, etc. A customer. A customer works with a broker but is not represented by that broker. The broker can only perform ministerial acts, not give advice or advocacy. I, a day. A day means a full calendar day ending at 11:59 p.m. The binding agreement date is day 0. J, material relationship. A material relationship means any relationship a broker has with a party, personal, family, business, that could affect the broker's judgment. K, AKA means not applicable and is used when a blank in the contract does not apply to the transaction. Warning to buyers and sellers, cyber fraud. Criminals sometimes send fake emails pretending to be the lender or closing attorney, giving fraudulent wire instructions. Buyer and seller should never wire money based solely on email instructions. Always call the attorney or lender using a phone number you look up yourself, not from the email. Criminals' emails often come from addresses that are slightly different from real ones. And that concludes page 8 of the purchase and sale agreement. Page 9 of the purchase and sale agreement, heightened identification procedures to help prevent fraud, covenant not to sue. Criminals sometimes pretend to be the property owner and try to sell a home they do not actually own. To prevent this, the seller must verify their identity immediately when the listing broker asks, the closing attorney asks. The seller must provide government ID, government issued ID, meet in person or via video to confirm identity. If the seller is an LLC, corporation, or trust, A, provide organizational documents. B, show ID for the person authorized to sign. Meet with the attorney or broker to verify authority. Broker acknowledgement. Even with all safeguards, identity theft can still happen. Buyer agrees not to sue broker or the closing attorney if a fake seller commits fraud. Limit on broker's liability. What this means. Brokers have strictly limited liability in this contract. Maximum liability, the amount of compensation they received, or $100 if no compensation was paid, whichever is less. Special rule for wire fraud. Maximum broker liability is $100 even if more money was lost. 9. Exhibits and addenda. Every exhibit attached to the contract must be checked off to be included. If a checkbox is not marked, the exhibit is not part of the contract, even if physically attached. Common exhibits include community association disclosure, condominium exhibit, financing contingencies such as FHA, VA, USDA, and conventional, lead-based paint exhibit, buyer brokerage compensation exhibit, seller's property disclosure, temporary occupancy agreement, legal description exhibit, backup agreement exhibit, or other custom addenda. Special stipulations. Special stipulations are custom terms written specifically for the contract. These override the main body of the contract and the exhibits. And that concludes page 9 of the purchase and sale agreement. Page 10 of the purchase and sale agreement. By signing this agreement, buyer and seller acknowledge that they have read and understood this agreement and agreed to the terms. If buyer or seller is a legal entity, this agreement must be signed by one or more authorized persons as required in the entity's legal documents. The person's signature must include the capacity in which the person is signing, such as trustee, general partner, manager, president, etc. You'll sign here to officially enter the contract. Your contact information matters because all legal notices are sent to the address listed. Your agent and the seller's agent also sign to confirm their involvement. The most important part is the binding agreement date because it's the date all deadlines start counting from. Once that's set and delivered, the contract becomes legally binding. And this concludes the purchase and sale agreement F201. Thank you.